Welcome, and thank you for viewing this Garden State CLE video. All Garden State CLE video programs can be seen for free 24 hours a day. Besides viewing the show, you can also earn CLE credits. In order to receive CLE credits for this program, you will have to do the following. First, download an evaluation form from the website. Just click on step number 3, and the form will appear on your screen. Please print out a copy. Next, as you watch the program, you will note that from time to time, a keyword will appear on the screen in red lettering. Write these words down on your evaluation form. Accurately recording these words is a required step in granting you CLE credits. Finally, at the conclusion of the show, simply complete the evaluation form and fax or mail it to Garden State CLE. Remember, viewing the CLE program is absolutely free. The only time you ever pay is when you want to receive CLE credits. You can pay for your CLE credits online or by sending in a check with your evaluation form. Now, sit back, relax, and enjoy the following Garden State CLE video from the comfort of your own home or office.
Garden State CLE. 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 Garden State CLE.
Richard Uslan, attorney at law. You admit to that, right?
I'm going to plead the fifth on that one.
Well, let me ask you this then, and try to answer truthfully. Would you consider yourself to be one of the more, not only handsome, but experienced drunk driving defense attorneys in the state of New Jersey?
Are you asking a trial attorney to be modest?
No, honest. An equally great challenge.
I've done my share, at least 1,000 or more
drunk driving cases.
Well, I'm being conservative.
Right, and certainly quite a number of trials along the way.
Several trials, and unfortunately, sometimes several appeals.
But it's when you say several, you're really kind of downplaying that. You've done quite a number of trials over the years, and
Yes,
know your way around a courtroom, especially in a drunk driving case. And I know you're famous for several of the controversies you've handled. One of which being the infamous, I guess the best way to describe it, Amiens case. And
I still get calls about that. It's been, I don't want to date this video, but it's been several years since that was decided, and I get calls at least a few a month.
Well, I want to date you, okay? Because you've been doing this for more than 35 years now, and have the perspective of someone who's had just an enormous amount of experience. But as the reality is that there's always new attorneys coming online, and our whole focus today is to try to bring them up to speed as quickly as possible on the basics of putting together a drunk driving defense, okay?
Well, it's certainly something that they will appreciate because it's very rewarding and it's enjoyable.
Now, 35 years ago when you started off, the statute was quite a bit different, but how did you go about learning this stuff?
Through the School of Hard Knocks.
Right.
I happened to, one of my few offices, but the office that I was at in my hometown happened to be right around the corner from the municipal court. And I guess because of proximity, I had a lot of people come visit me. And when you're starting out on your own, you begin taking practically everything, and then you find out what it is that you like to do and what you feel that you're competent to do. And one thing led to another, and I'm interested in it because I do have some science background in the physical and chemical sciences, and this gives me an opportunity to use that as well as the law.
What I'd like to do, though, as a starting point, is to take current day New Jersey law and really kind of set the stage for a young attorney who has his first or second client coming in with a drunk driving case, and try to familiarize the attorney with what you're confronted with and some of the practical steps you can take to put a defense together for your client. And one of the things that I worry about when I think about these things is reading over, for example, police reports where there may be a very important issue where you and I would spot right away just based on our experience in dealing with these things, where it might just go right over the head of the new attorney. So I want to kind of sensitize the people who are watching this training video to that extent. Okay?
That's an excellent idea.
Now, let's start off with just kind of a brief discussion of the law. There are multiple ways that you can be found guilty under the statute, and I want to kind of talk about each one of them, so what the state's philosophy on the case will be. Now, the first one is the one that we're all most familiar with, and that's called the per se violation. An individual who operates a motor vehicle in our state with a blood alcohol level of 0.08 or greater basically is guilty of the offense of operating under the influence of alcohol.
Certainly, if that's admitted into evidence.
The key is that the blood alcohol level has to be taken within a reasonable period of time after operating the vehicle. And by that I mean that there can't be any undue long-term delay, and certainly no ingestion of alcohol between the time of the operation and the time of the taking of the test. Would you agree?
Yes, I do.
But that having been said, if the state can establish that you operated a motor vehicle and that within a reasonable period of time after operating the vehicle you submit to a breath test and the results of the test are 0.08 or greater, the case is basically over at that point.
Well, that's true, but take a step back. There still has to be probable cause to begin a DWI investigation, and to a lesser degree, because it happens infrequently, but it does happen, the court has to have jurisdiction to hear the case.
Well, these go by way more of defenses, but just in terms of the nuts and bolts steps that the state is going to take to prosecute, it's really in a per se case pretty straightforward, don't you think?
Yes, it is, and it's going to make it more challenging for new practitioners, especially because of the advent of the ALCO test.
It's important that young attorneys understand, and when they explain this to their clients, that when we're talking about a per se violation, the offense is being a 0.08 or greater within a reasonable period of time after operating the vehicle. So it's a strict liability offense in the sense that it doesn't require any culpability state. It doesn't matter whether it was your intention to be that high or you didn't know that you were that high. In fact, it doesn't even matter that you didn't realize you were consuming alcohol beverages. None of that matters. It's all been taken out through the case law. And the evidence of your blood alcohol level can basically come from two different sources. One from some type of recognized breath testing device like the ALCO test that we use now, although I guess they could use a breathalyzer under certain circumstances. And the other way would be through blood.
Yes.
Evidence of your blood alcohol level. Typically, this will be from a sample that was taken in a medically acceptable manner in a medically acceptable facility. All right.
Or a police kit that's brought to the facility for the phlebotomist to utilize.
Exactly. So all those things together will establish evidence of what the blood alcohol level was. And as I said, if it's a 0.08 or greater within a reasonable period of time after operating the vehicle, the case is over at that point.
That's right.
Let me ask you this, just as a practical matter. If you had evidence that went in at the end of the state's case where the judge had admitted the BAC at its 0.08 or greater, and it was taken with a reasonable period of time after operating, is there any defense you can think of that you can actually raise at that point to the charge?
Once it's been admitted into evidence?
Once it's been admitted into evidence.
And they've established operation?
Correct.
I don't believe so.
I think the case is over. I mean, at that point, under the per se violation, the case is over. Mm-hmm. So it's important for young attorneys to understand that when you're counseling a client, they should really be familiarized with the per se violation and the strict liability nature of that part of the violation.
Well, yeah, the thrust of the defense is going to be to try to exclude that breath test result or blood test.
Typically, that's going to be one of the most important things you're going to want to try to accomplish. Many times, that's the victory that you're going to get in the case. Now, the second way people can be convicted of operating or drunk driving in our state is by operating under the influence of alcohol. And it's important for young attorneys to understand that there really is no logical relationship between the per se violation and being under the influence of alcohol, because you can have an individual who is legally intoxicated in the sense that his blood alcohol level is, say, 0.08 or 0.09, but that individual would not be under the influence of alcohol. Typically, you'll see this in individuals who are inveterate drinkers, very, very experienced drinkers. And it takes a whole lot of alcohol for them to show any outward effects of it.
Well, I agree with you. I often counsel my clients, particularly the ones that can hold their liquor, that it's not how well they hold their liquor, it's how much liquor is in them.
Right. Now, alternatively, you could have people who are substantially below the per se level, let's say 0.05, 0.06, 0.04, something like that. And these are individuals who would be profoundly intoxicated because their body is just not used to dealing with alcohol. And you see this a lot with young people who, they're just not experienced drinkers because they haven't lived long enough to become experienced drinkers.
And the law allows those people to be prosecuted. Just because they're under the legal limit doesn't preclude the prosecutor from attempting to prove the case.
So it's important that the people who are watching this understand that the state will be able to make out a case, irrespective of what the BAC is, based upon the evidence showing that the individual operated under the influence of alcohol. Now, interestingly, the concept or the definition of operating under the influence of alcohol is not in the statute. It's developed totally from the case law. It's been around for a long time. And just kind of paraphrasing, it means that your mental faculties and your physical capabilities were so deleteriously affected by the consumption of alcohol that it was unsafe for you to operate a motor vehicle. And typically, what are the types of things that the state will utilize in order to demonstrate that you were in fact under the influence of alcohol? What do they do?
Well, the manner of driving,
right?
Physical manifestations such as an odor of alcohol on breath, or oftentimes you see in the drinking driving reports bloodshot eyes, flushed face. They also attempt to utilize they should try to use standardized field sobriety tests, but
right.
There's a whole panoply of physical tests that they can conduct on the road. Those are several of the examples, admissions of what a defendant may have decided to tell the police they drank.
Right.
Those are all the factors, and then some, that the prosecution would attempt to use to meet the standard you just described.
So let's go through them kind of step by step. First of all, you have operation of the vehicle, and typically it's all circumstantial evidence. You're asking the judge to draw inferences of guilt from various pieces of evidence. So the operation of the vehicle could involve weaving within a lane, or could involve some excessive speed, or sometimes very, very slow speed. And there's really two parts to this. Number one, it may provide a reasonable and articulable basis for the police to effect a motor vehicle stop, or it may provide the basis for the police to think that maybe this is somebody in trouble and the police have to get involved in the case on a community caretaking basis.
Mm-hmm.
But that's also evidence of an intoxication. If there's an accident, this again raises an inference that alcohol may have played a part. The fact that the individual was under the influence of alcohol may have played a part in the occurrence of the accident.
Sleeping in the car.
Sleeping in the car, passed out behind the wheel, irrespective of whether the engine is running or not, also circumstantial proof. The observations of the officer at the scene in terms of the odor of an alcoholic beverage on the breath, bloodshot and watery eyes, slurred speech, general demeanor, fighting, hilarious, whatever it may be. And then, of course, you have the admissions that the defendants will make. How many times have you seen defendants say they admit to the officer that they're drunk?
Well, you know what it is? I've thought about this a lot. A defendant always thinks that by cooperating with the police, by being polite, by spilling their guts out to the police, that all of a sudden the police are going to say, I really appreciate your honesty, so I'm not going to prosecute you for this.
Right.
And I think that's where all of that stems from, rather than exercising your Miranda warnings, which quite often the police don't tell the defendant in a timely manner, by the way.
Have you ever seen a defendant who's able to talk his way out of this?
Not once they're at the police station.
It's really tough out on the street, too. The police are very suspicious. Did you ever notice that? But in any event, these are all pieces of circumstantial evidence that are intended to have an inference of guilt raised to the mind of the judge who's trying these things. Then, of course, you have things that are much more structured, as you mentioned a few moments ago, the field sobriety tests. Standardized field sobriety tests for officers who are trained in this will provide various clues that the officer can utilize to testify in court that this was an indication of some level of intoxication. Typically, there are 3 field sobriety tests that the police utilize: the so-called horizontal gaze nystagmus test, the walk and turn test, and the one-legged stand. These are the only 3 field sobriety tests that really kind of are utilized universally throughout the United States.
And oddly enough, each of them individually have no more than, I believe, a 67% likelihood of demonstrating someone who would have a .08 reading or above.
It's funny because I think a lot of them were developed at an era when the BAC was .10, and I don't know what scientifically the correlation they've made since the whole country became a .08 standard. I will tell, it's important that our viewers understand that as far as the horizontal gaze nystagmus test is concerned, the appellate division of the Superior Court has ruled that that is not scientifically reliable enough to be utilized as substantive evidence of guilt during the course of the trial. However, the appellate division also suggested that judges can consider it at least for the purpose of establishing probable cause to believe that the defendant is operating under the influence of alcohol. So it has some limited utility. It's interesting on these field sobriety tests we just talked about because they're really kind of a two-edged sword, or actually a three-edged sword. Number one, they can be utilized by the police to establish probable cause to believe the individual's under arrest, or excuse me, to establish a person's probable cause to believe the person's under the influence of alcohol and thereby arrest him legally. Number two, they can constitute independently substantive evidence of guilt. And number three, if you refuse to do them, the judge can draw an inference of guilt by your refusal to perform those tests, right?
Yes.
So can anything good come out of these tests?
Well, the answer actually is yes, because occasionally you run across a case where someone is seeing you for something other than the DWI, but they originally were suspected of driving under the influence and performed the field sobriety tests admirably.
Right.
And the police officer decided under those circumstances not to issue the summons. It does happen. And so the fourth thing that in a perfect world field sobriety tests can be utilized for is to exonerate someone.
Right. Sometimes you'll have to pay attention to these things if you're going to defend one of these cases and become familiar with the proper way that field sobriety tests are administered, make sure that they were properly explained to the subject, make sure they're properly demonstrated to the subject, and make sure that the conclusions that the officer draws from the tests are reasonable. This is
Otherwise, they're not standardized.
Exactly. And it's always easier when there's been some videotape taken of the performance of these tests, but sometimes there is no video, sometimes it's very poor quality, and sometimes it doesn't have anything on it except the voices of the participants. So it's kind of like playing poker. You just take the hand you're dealt with. By the way, that should be a subject of another CLE we should do with you, poker law. But I digress. So just to go back for a second, when you're dealing with alcohol, there's really two different ways that the state can go forward and prosecute the case then. Number one, to make a determination of what your BAC is and demonstrate that there's a per se violation, or alternatively, to demonstrate that you operated under the influence of alcohol. And typically, the state really should...
By observation.
Correct, by observation. And typically, the state should be, when the evidence is there, the state should be doing both prongs. And the municipal court judge who's hearing the case should make factual findings both on under the influence component as well as the per se component.
That's the Kashi case.
That's right. And you should understand, too, you may have a situation where the judge will say, I'm not persuaded that you were under the influence of alcohol, but I find you guilty of the per se violation. Or alternatively, I find you not guilty of the per se violation because of some ethical, or not ethical, but evidentiary issue on the way the police got the blood alcohol reading. But by the same token, I find you were under the influence of alcohol within the meaning of the case law that we just talked about. And it really doesn't matter except in one limited instance for sentencing. Either way, you're going to be guilty, right?
Yes.
Okay.
For a first offense, it might matter.
For a first offense non-school zone, it would make a difference, and we should remember to talk about that when we come back and discuss that. Now, the next major kind of category we have to deal with is, and this is really gets much more complicated, is operating under the influence of drugs, controlled dangerous substances.
Yes.
The definition, again, is not in the statute. It comes through the case law, very similar to the definition of operating under the influence of alcohol. But the proof issues are dramatically different. First of all, how does the state put a case together when they want to demonstrate that someone operated a vehicle under the influence of drugs as opposed to alcohol?
Well, first of all, the statute provides that you could be under the influence as a result of a narcotic, a hallucinogen, or a habit-producing drug.
Or a drug that gives you a narcotic effect.
Yes. Marijuana is an example because I believe marijuana has been determined by our courts to be a narcotic.
Right.
Generally, this type of evidence would be through urine quite often. Mm-hmm. And oddly enough, that would be circumstantial because we're generally looking at non-active metabolites. Once the drug has been broken down, in your body and comes out as waste in your urine, it's the byproducts of the original drug that are being used to demonstrate that you had taken the drugs and then that you were under the influence of them.
Well, it's very important that everyone understand, looking at this, when you have evidence that comes through a urine sample, that is not evidence that it was in the bloodstream of the defendant recently, because it could have been in the body tissue, in an organ, or something of that nature. The only evidence to suggest that a particular substance was in your blood is from a blood sample. And so many times the police will have evidence of the presence of some type of controlled dangerous substance, cocaine or whatever it may be, that comes about from a blood sample taken from the body of the defendant, again at a time close to the time of the operation of the vehicle. So you have your choice either way, but again, it's important to understand that the urine test is a little bit different in the sense that it's not direct evidence that it was in the bloodstream at the time of operation.
Well, that's right. And they may try to use the testimony of a forensic chemist that did the analysis to demonstrate what these byproducts were and what they're byproducts of to take the next step and say that they were under the influence of it, and that might very well be beyond the scope of their expertise. Particularly also, this might be a toxicology issue where we're talking about half-lives of the medication or illegal substance, or the concentrations of the waste that you can extrapolate back to determine, what amounts of drugs were ingested.
And you raise a very good point, because in New Jersey, when you get laboratory reports from the State Police Forensic Laboratories where they've tested either a urine sample or a blood sample, what you're going to get is the presence or absence of certain substances, but you don't get any quantitative report on how much was in there. You just get presence or absence. So it makes it difficult for the state to completely rely upon just the mere presence or absence. That's only a piece of the puzzle. It doesn't necessarily show that the individual is under the influence of that substance within the meaning of the case law.
And also, by the way, we're not necessarily talking about people who are ingesting either illegal drugs or drugs that were not prescribed to them, or drugs that may have been prescribed to them that they abused. We could be talking about people who were lawfully taking medication.
And they found you're guilty of driving under the influence of something that had a narcotic effect. You'd be just as guilty, right?
That's right.
Now, one of the things major distinguishing factors between a drug case and an alcohol case is this. It's been the law in our state since the early 1880s, and maybe even back to colonial times, that lay people are permitted to render an opinion in court that someone was under the influence of alcohol. It's just something that is rationally based upon the perception of most adults. They can tell or give a pretty good indication that somebody was under the influence of alcohol. That is not the case, generally speaking, with being under the influence of drugs. So one of the things the state is going to have in one of these cases where they're going to try to demonstrate that someone operated a motor vehicle under the influence of drugs is some level of expert opinion to say that to the court that this person was under the influence of drugs. Now, one exception that you get in these types of cases dealing with the quality of the evidence, the expert evidence, is in the marijuana case. Our Supreme Court has found and held in a very important case called State versus Beeler that police officers, based upon their training in the police academy, typically will qualify as experts for the purpose of rendering an opinion that an individual was under the influence of marijuana. Whether that's a good supposition or bad is really, we're way beyond that at this point because the court has, they've announced their rule of law and we have to kind of live with it. Right?
They still, however, I believe, and you're the absolute maven on this, but they did indicate a preference to have expert testimony.
Well, there's no doubt about it. But you see, the police officer in the marijuana case will qualify as an expert. Typically, if the prosecutor takes him through his training and experience in the police academy, it's such a low threshold that the officer should qualify and be able to give an opinion. Now, the amount of weight ascribed to that by the judge is a completely different issue. Just in terms of qualifying and being able to give the opinion, though, regular police officers in a marijuana case should be able to do that. For other types of cases, though, you're going to need someone who has a lot more expertise. So to say that someone was under the influence of a narcotic or something that had a narcotic effect or something that was hallucinogen or that was a habit-producing drug, all these things are going to require expert testimony for the court to make that determination. Now, the Beeler case talked about something else, too, and basically the issue was whether or not, if you don't have any expert testimony at all you have is evidence of the consumption of some type of controlled dangerous substance, drug, whatever it may be, and wacky driving, can the judge, as fact finder, kind of logically make the connection and attribute the crazy driving to the presence of the controlled dangerous substance? And the Supreme Court found, reversing the appellate division, that yes, judges in their function as fact finders can make the determination. But as you say, the preferred way of doing it is by having expert testimony. You agree with all that?
Yes, I do.
Now, you've been involved in something like this, right?
Yes, I have.
Many times.
Yes.
And this is kind of where this Ambien issue came up. So I imagine these are all arguments you raised during your Ambien case.
Yes. That was certainly a different case in many respects, not just because of the results of drugs that were not known to the consumer, that sleep driving can result from taking Ambien, but also it really did inject and it's very rare because DWI is a strict liability offense, it did inject the issue of intent to drive into a DWI case, which is extremely rare.
I need to get back to that when we talk about some of these elements the state's going to have to prove in every case. But just to kind of finish off on the issue of driving under the influence of drugs, typically these cases are going to go as follows. The police will detect crazy driving, something that will cause them to stop the vehicle, or it may be an accident. It may be somebody passed out on the roadside, might be a roadblock, could be a million things, okay? Mm-hmm. But at that point, the police will either make an observation by either smelling, say, for example, marijuana inside the vehicle, finding marijuana by conducting some type of a lawful search. They may recover some type of other controlled dangerous substance, could be cocaine or something of that nature. The activities or the conduct of the defendant will be such that the police will start to suspect this is an individual who is under the influence of alcohol and or drugs. Now, the police will arrest the individual and bring him back to the police station. And the first step the police will do, always, is to give this individual the opportunity to take an alcotest case. Even in those instances where they don't detect any odor of an alcohol beverage on this individual's breath, if there's a very low reading of blood alcohol or none, which frequently happens, but yet the individual is still kind of wacky, that's going to lead the police to believe that this individual was under the influence of drugs. What the police will then typically do is one of two things. They will either voluntarily ask the defendant to provide a urine sample, or they will take the individual to a medical facility for the purpose of having blood withdrawn from the body of the defendant.
Or they will also have him evaluated by a drug recognition evaluator.
Correct. And that can happen either at the police station or at the hospital. My sense is the police, since blood evidence is in the words of our Supreme Court, evanescent, they really want to kind of get the sample as quickly as possible so that they can tie it back to the time of operation. So it's important when you're talking to clients to have them understand that you don't have a right to refuse to give a blood sample, and that there's no search warrant or anything like that required because of the exigencies of the circumstance of the situation.
Let me ask you that, Bob.
Sure.
This troubles me.
Why?
Well, because the refusal statute, I thought, only discusses refusing to give breath samples.
And not only does it do that, it also prohibits the police from forcibly taking a breath sample. That's right in the statute.
Right. So then what violation of law is it to refuse to submit to providing a blood or urine sample?
It isn't. It's not a violation of New Jersey law. However, the case law suggests that judges are to draw an adverse inference when a defendant refuses to voluntarily give a blood or urine sample. So,
but isn't that based upon the statute that they violated?
No, it's strictly based upon the case law.
All right.
So while it's not an offense under New Jersey law, it doesn't help you at all in your case if the judge draws the proper adverse inference against you. The evidence is going to be the reason he didn't take the test is because it would have revealed additional evidence of guilt, or it shows consciousness of guilt.
Now, is it an adverse inference, or can it just be utilized as evidence of intoxication?
Well, it's the same thing. I mean, it's just a permissive inference that the court can draw. There's nothing mandatory. You can't have a conclusive presumption in a quasi-criminal case, right? It would have to be a permissive inference. So that comes through the case law, and in terms of the amount of force that the police can utilize, they can strap you down to the table and take the sample, but the amount of force that the police utilize is really kind of on a sliding scale, in the sense that you have some cases where there's no accident and nothing really in play except a drunk driving case. So the amount of force the police could utilize to extract a blood sample is relatively small. At the other extreme, you have a case where there's been a couple of homicides, or you have victims who may die, and the police need that blood sample, and they need it now because this is going to be the sole evidence they have of the recklessness of the operator. So under those circumstances, a significant amount of force could be utilized by the police to extract the blood sample from the body of the defendant. So I mean, it's important that everyone understand, kind of going in, that there is no right to refuse to give the blood sample, and that the police can utilize a reasonable amount of force in extracting the blood sample from the body of the defendant. Now, I think theoretically the same law would apply with respect to the extraction of a urine sample, but it's a much more complicated, much more painful and dangerous procedure to forcibly take a urine sample out of a human being. And I'm not so sure that the New Jersey Supreme Court or even the United States Supreme Court would countenance that level of invasion of the body on a forcible level. I can't imagine that happening. I mean, going back to the Schmerber decision back in, I don't know when it was, 66, I guess, one of the things that made it constitutionally palatable was the fact that the blood could be taken without a lot of pain and in relatively safe manner, with minimal chance of infection and things like that. You certainly don't have that when you're going to try to involuntarily put a catheter in another human being. So I think that the law would be different. And the cases that I know of, I think there's one main case dealing with involuntary catheterization of an individual. It turned out badly for the for the government. I think the township of Nutley got sued for a lot of money on something like that. So, but anyway, getting back to our analysis on drugs, part of the evidence is going to come from the presence or absence of certain controlled dangerous substances, narcotic, hallucinogen, habit-producing drug, narcotic effect, It's not necessary that the state demonstrate what specific drug it was that was causing that. They don't even have to show how much of a particular drug. All they need to do is, to make their case, typically is have evidence of the drug, evidence of crazy driving, and an expert who can tie all this stuff together.
You know, there's one substance in particular that really emphasizes the point you're making, and that is a drug called I think the trade name is Soma. Mm-hmm. Soma is a substance which, before it's ingested, is not a narcotic, but it is broken down into a scheduled narcotic. Once it is ingested in your body, a byproduct is a narcotic. So now that could go either way, depending upon what judge you're before or what prosecutor you're in front of. But in theory, it's what effect that has on you. Mm-hmm. That really controls.
It's the
not the fact that it's a narcotic.
It's the narcotic effect, right? And by the way, this narcotic effect business we're just talking about, this comes through the case law. This is not in the statute. The statute just talks about narcotic hallucinogen and habit-producing drug, but the narcotic effect comes through the case law, so that's in play, and everyone should know about it. So this is what the kind of the evidence that the state's going to have to put forward in order to persuade the judge that the individual operated well under the influence of drugs.
So what is a defense attorney going to do now to try to challenge that?
Well, drug and urine cases have become much more complicated than they used to be from the state's perspective. They're very difficult cases to try, not only substantively but also procedurally, because of decisions by both the New Jersey Supreme Court, but also starting from the United States Supreme Court, dealing with confrontation clause issues. So it becomes incumbent then on the state, if the defendant wants it, to produce pretty much everybody who was involved in the case, not only in terms of the chain of custody, but most importantly the people who drew the blood sample or urine sample, people who actually tested the sample, the chemist or scientist, technician, whoever it was, and have these individuals come into court and be subject to cross-examination.
Well, an important practice point is make sure as a defense attorney that you make that demand within 10 days of your receipt of the laboratory report.
Correct.
Just to exercise on the side of caution.
It's more than caution. I mean, if you don't do it, they actually could say you waived your right to challenge these individuals.
Right. So make sure that you do that, or else you won't have the opportunity to put the state to its proofs using all of the personnel that you've described.
There are quite a number of other defenses that you can raise. Some of them are related to the fact that the psychological, or the physical manifestations demonstrated by the defendant were not sufficient to show that he operated under the influence. You can challenge the opinion of whatever expert they utilize. Let's say it's a drug recognition expert, and you could attack the bona fides of the expert. You can make the argument that it's not recognized as a field of expertise, but it's really kind of junk science. You could attack the record or the accuracy of previous tests that have been administered by the DRE.
Introduce your client's medical history.
That's another possibility. You could challenge the way the blood sample was actually, or urine sample was taken on a constitutional basis, or just in terms of the practical aspects of the way the sample was handled or extracted. The conduct of the police was not reasonable, or that there was no justification for them taking the sample in the first place. I mean, there are quite a number of defenses that you can raise in these cases. But just in terms of the nuts and bolts of it, it's going to be lack of any blood alcohol evidence or low BAC with a disproportionate effect of something affecting the defendant. The police then having the defendant examined by some type of DRE expert if they have that person available. And then having blood or alcohol sample taken from the body of the defendant fairly quickly after the time of operation for the purpose of forensic analysis.
Now, Bob, you've mentioned a few times that the sample has to be obtained within a reasonable time.
Correct.
What does the case law say a reasonable time is?
Well, see, I'm not really aware that they've ever come up with what a reasonable period of time is in the blood case. In the alcohol case, this comes out of State versus Tissio is the main case that deals with that. And there have been 3 appellate division cases since Tissio which require that the sample be drawn within a reasonable period of time. I would have to get an expert to really kind of say, what the impact would be.
Well, the reason why I ask is because I can't cite cases, but I am aware of having read cases where, for example, 2 hours was a reasonable time.
It's probably Dana Miller case.
In some instances, in one instance perhaps, as much as 4 hours was a reasonable time.
Well, it's interesting how you say that, because it was that 4 hours was based upon the defendant's own estimate as to when he stopped driving. Apparently, the police found him on the side of the road, took him in, and took his results from him fairly quickly. If you use his timeline, you're saying, "Oh, I've been stopped at the side of the road for 3 hours before the police found me," it would have been 4 hours. But there's really no definitive time that's come up so far. And the whole purpose behind this in the Tissio case was to prevent the police from bringing somebody in and then just delaying the administration of some type of breath test, so that the defendant, when he took the test, would be at the maximum level of his BAC, assuming that all the alcohol in his body had been absorbed into his bloodstream, rather than having half of it be in his stomach, where it wouldn't be reflected in his blood alcohol level.
You know what we haven't talked about, I don't know if you want to discuss it now or not, is we're talking about breath samples before. What is the importance of making sure that the breath sample is untainted, and under what circumstances do you attempt to challenge a sample as not to claim that it is tainted and shouldn't be admissible as evidence?
Well, the instrument that is utilized in New Jersey now is the Alcotest, and in State versus Chun, the Supreme Court reported what the proper steps were in terms of the operation of the Alcotest. One of the steps involves watching the defendant for a period of 20 minutes before he or she takes a test to make sure that contaminants that might have been in the individual's mouth are taken away. So
you're talking about an observation deprivation period, so
right.
Also to make sure they have nothing in their mouth.
Correct. So to make sure that any foreign object in the mouth, maybe a tongue ring, or I had a defendant with a penny in there one time, any residual alcohol in the mouth from any source, be it mouthwash, alcohol from burping or things of that nature.
I was going to say regurgitation.
Regurgitation. All these, the 20-minute observation period is intended to let any residual alcohol in the mouth dissipate, so that the sample that goes into the instrument comes from the deep part of the lungs as opposed to from some alcohol in the mouth cavity.
Well, the deep part of the lungs is where all the blood vessels, there are more blood vessels in that area that more closely simulate the body temperature.
Closest to arterial blood is basically what you're going to get from that.
And because the Alcotest is designed in such a way that it's calibrated according to the approximate body temperature, you want a sample that's going to most closely simulate that temperature.
That's correct. The Alcotest also has kind of algorithms built into it where it will, on occasion, detect mouth alcohol, detect anomalies, and kind of stop the test and say, no, this is an improper test.
That's the slope detector.
Slope detector is what that's called. And that, on occasion, will pick up any contaminants that you have. But, sometimes the police, they don't follow the proper procedures. And let's say, for example, the police note that there's something in the defendant's mouth. Many times they'll just have him remove the object from his mouth, and they should technically start the 20-minute waiting period over again at that point. Or if the individual throws up, which happens a lot. Very entertaining, by the way, if they have it on videotape. But you'll see the police will, kind of let them clean their mouth off and then give them a breath test rather than waiting the 20 minutes.
Certainly, that's something that practitioners should pay close attention to. Sometimes the officer, in the process of doing the first test, attaching the mouthpiece to the end of the hose, finishes that test and then leaves the room to get another mouthpiece, comes back in to do the second test, and there goes, there's a break in that 20-minute observation deprivation period.
I've also seen them where they don't change the mouthpiece as well, so there could be residual molecules of ethanol on the mouthpiece. Rich, I want to just kind of go back to a couple of additional ways that the state has of going forward in prosecuting a drunk driving case. We've talked about the most common way is going to be through under the influence of alcohol, less so with under the influence of drugs, but that happens. Another option the state has is to demonstrate that the defendant was operating under the influence of chemical inhalants. And this is very, very rarely prosecuted, but it's out there. The statute lists a large number of chemical inhalants that people can take into their body, but that's not meant to be an exclusive list at all. And pretty much anything that would produce a state of intoxication in you is going to qualify as a chemical inhalant under the statute.
And that would be involuntary intoxication generally, which isn't a defense.
Or could be voluntary as well. You know, you have people engaged in this this so-called, they call it huffing, I guess is the street name for it. But you also have cases where people, they're painters and things of that nature. They're breathing in fumes all day.
That's occurring with them that isn't normal, that perhaps they shouldn't get behind the wheel. They may not be able to put their finger on it, but there's something that's preventing them from driving safely, whether it's because they're lightheaded from being in an enclosed room while they're painting or whatever it is. That's part of the rationale.
Well, there's another part of the rationale, too, in terms of why the courts have made these strict liability offenses. And what they're trying to do is to eliminate what they determine to be defenses that are based upon a mere pretext. So that, it'd be very easy for somebody to make up a defense who was under the influence of a chemical inhalant, that it was done accidentally and he didn't realize it, and it was because of environmental factors at work, and all of which may be true, but the idea being that the odds of somebody raising that as a pretext are so great that just as a matter of policy, the courts won't permit it. It's a strict liability offense. Now, one of the additional ways that the state has of proving a drunk driving case is to demonstrate that an individual allowed the intoxicated operation of a motor vehicle, and being a vehicle for which he is responsible. Typically, there's two ways of demonstrating this, and the law is not all that well settled on this, so I'm just going to give you my opinion, and if you're an advocate, you've got to kind of go your own way. For individuals who allow the intoxicated operation of a motor vehicle, and by that I mean that the state's theory of the case is that the operator was under the influence of alcohol, not a per se violation, but under the influence of alcohol. Although when you read the statute, it appears to be pretty much of a strict liability offense, the case law says otherwise, and it's incumbent upon the state to demonstrate a knowing component for the defendant, meaning that the defendant knew or should have known from the attendant circumstances that the person whose car he was going to permit the operation of was under the influence of alcohol within the meaning through the case law that we talked about before. So that becomes an additional element that the state's going to have to demonstrate. My sense is, though, that when you're dealing with a per se violation, in other words, let's say I turn my car over to you, I give you the keys, you drive the car away and get stopped by the police, they arrest you, bring you back in your .08, my sense is that the law would impose strict liability on me, that I wouldn't, there is no culpability state. The state wouldn't have to prove knowledge on the per se violation. First of all, it would be impossible for them to ever prove that I knew that you were .08 or greater, and it's per se, So this is a danger that you take by letting somebody drive your car, right?
Yes. It's also important, though, that you mentioned letting them drive your car as opposed to the intoxicated person driving their own car.
Sure. I mean, it would have to be, and it's not really necessarily a question of ownership. It's really a question of a vehicle that you're responsible for, that you're the rightful possessor of, or at least the rightful possessor of the keys. In other words, you have the power in some meaningful way to control who's going to operate the motor vehicle. If you allow someone to operate who's under the influence of alcohol, and the state can prove that you knew this individual was under the influence of alcohol, but you let the person drive anyway, that's going to bring you in under the statute, and you'll be found guilty of being an allower. A much more difficult question, and the case law has not explored it yet, this is just my theory, that if it went to the appellate division, this is what they would say. you allow an individual to operate your motor vehicle, and it turns out that person had a BAC of .08 or greater, with no evidence you're under the influence of alcohol, you would still be guilty, but on a per se violation. It's a strict liability type of violation as an allower.
And tissue may be a factor here, because suppose you weren't with that person that entire evening. You
weren't with them at all.
You weren't with them at all. You didn't know what or how much they were drinking.
Right.
And obviously, alcohol reaches its maximum level in your bloodstream an hour or two after your last drink.
Right.
So when that person first got into the car, and suppose they're going from Somerville down to Atlantic City in a couple hour drive
to play poker.
To play poker.
Okay. And win $1,500.
Yeah, but let's suppose, for example, that when you first handed the keys over to that person, you smelled a little alcohol. You could take a sip of beer and you'll smell alcohol on your breath.
Right.
But then what happens? The person becomes increasingly intoxicated over time. And it's difficult to be able to say at that point that initially that you had a reasonable belief, or that you can actually be punished for allowing the person to drive under those circumstances.
Well, if it's a strict liability offense, none of that's going to matter. And my sense is that if it went to the appellate division, they would hold it to be a strict liability offense. But we'll see. I think you can't go wrong, though, if you're a defense attorney, by assuming that it's a strict liability offense and defending the case accordingly. Okay? I mean,
you can't represent the two of them. You're going to have to make sure that the driver has able counsel to try to get an acquittal and save your client's rear end.
You get 2 legal fees, though. All right. So these are basically, just to kind of recap, these are the ways that the state will generally go forward to prove one of these cases. We have the per se violation, operating under the influence of alcohol. We have the allowing offenses, which would involve either being under the influence of alcohol or a per se violation. We have operating under the influence of narcotic, hallucinogen, habit-producing drug that has a narcotic effect, and chemical inhalants, right?
And we also have, I don't know if you want to discuss this at all, or now or later, status offenses involving underage drinkers and commercial drivers.
I want to come back to that because they really are dependent upon the BAC. I mean, we can talk about them briefly now, since we talked about the per se violation. For the commercial driver, it's very, very easy. If the BAC is .04 or greater, guilty. Okay?
If they're driving a commercial vehicle.
If they're driving a commercial vehicle. And for the people who are underage, the statute requires, as one of the elements, that the state demonstrate what the BAC was. And the BAC has to be at least a .01, but less than a .08.
Now, I agree with you, but in practice, I'm finding that if judges, by observation, would be able to determine alcohol consumption, that they're going to convict this person.
And I think if it goes to the appellate division, they're going to be the conviction is going to be overturned. I mean, it's an element of the proof that the state has to demonstrate.
What about with a refusal?
What about with a refusal? The refusal is a refusal. If you're an underage drinker and you refuse, then you get found guilty of the refusal charge.
And you're acquitted. And you're acquitted.
You're acquitted of the underage drinking because they can't prove what your BAC was. So I'm not so sure that helps you.
In your practice, no, I know, but in your practice, have you found that to be the case? I haven't. That's why I'm asking.
No, I have not found that to be the case. All the kids that I represent, they all take the breath test. They're good kids. They drink too much, but they're good kids. Actually, they drink just enough not to be a .08.
Or a .10.
Or no,
I'd be .01.
They have to be a .01 at least. Otherwise, they don't qualify. Now, I want to talk about a couple of just some evidentiary issues that we can deal with these very, very quickly. These drunk driving in New Jersey is not a criminal offense. It's not even, it doesn't qualify as a crime. It's just not even within the category of offenses that we consider as crimes. Crimes are matters that involve they're cases involving jail terms that exceed 6 months.
And there's the mens rea.
And, well, there usually is a mens rea element associated with it, too. But they're petty offenses in the sense that they call for jail sentences which are less than 6 months. So there's no entitlement typically to a jury trial or to indictment. They're just not considered to be crimes. They're traffic tickets, okay? So individuals who get arrested for these things you should explain to your clients that, look, you have not been charged with a crime. It's not considered to be a crime under New Jersey law, which is unlike many of the other states where it is a crime, sometimes a very serious crime.
And you're entitled to a jury trial.
And you're entitled to a jury trial, but not in New Jersey. It's just a traffic ticket like anything else. But it has extremely significant consequences. But technically, it's important that clients understand they have not been charged with a crime, and if they're convicted of drunk driving, they have not been convicted of a crime.
Now, there is at least one instance where it would be a disorderly persons offense, or at least punishable as a disorderly persons offense. For example, if you have a minor in the vehicle.
Right, if you had one of your own children, for example, or two of your own children. But that's a separate, independent offense. I mean, it's a separate.
And it's still not a crime.
And still not a crime, disorderly persons offense, a petty offense. Now, notwithstanding the fact that we're not dealing with a criminal violation in the strict sense of the word, many of the aspects of criminal practice apply in the drunk driving context. First is that you're entitled to a trial where the proofs will have to be demonstrated by the state beyond a reasonable doubt. Okay, and it's important that you kind of keep this in the back of your mind, that although that there's no right to indictment or trial by jury, all of the other components of the Sixth Amendment and the Fifth Amendment, for that matter, and the Fourth Amendment too, for that matter, apply in the context of the drunk driving case. So you're entitled to counsel. You're entitled to appointed counsel if you can't afford your own attorney. You would be also entitled to challenge the admissibility of evidence against you if there's a Fourth Amendment issue. But the most important starting point is you understand that each element of the drunk driving offense, no matter which offense it is that we're talking about, must be proven beyond a reasonable doubt. And while we're at it, we should mention for the refusal offense, that is also required to be proved beyond a reasonable doubt, notwithstanding the fact that the statute says that the burden of proof is preponderance of the evidence. The legislature is still not caught up with the case law. The case law requires that the proofs be done by proof beyond a reasonable doubt. Okay, very important context to understand. There are different levels of proof that come up in the context of a drunk driving case. You pretty much get the full spectrum in the sense that, let's say, when we're talking about the admissibility of alcohol, blood alcohol level from Alcotest, there are certain foundational proofs that the judge has to consider before admitting the test. And the standard of proof for the admissibility of those proofs is by clear and convincing evidence. So you'll have that in play. If you file a motion to suppress evidence in the case, typically the burden of proof is going to be by the civil standard of preponderance of the evidence. And of course, if you're dealing with the evidence that supported the arrest, you'll be talking about probable cause. If you're dealing with evidence that led to the stop of the vehicle in the first place, you'll be dealing with issues of reasonable and articulable suspicion. So you really have the complete spectrum of proofs that you would get in the criminal justice system kind of embedded into a drunk driving case, right?
Yes, and the practitioner should also be looking at Part 7 of the Rules of Court.
Why would that be?
Well, because that deals with the municipal court as opposed to criminal matters in the superior court that are under Part 3.
And, you know, it's the key to all this, of course, what keeps it in the municipal court is the fact that since the maximum jail term you can get in a drunk driving case does not exceed 180 days, then there is no right to a jury trial. That means, by definition, and the municipal court, since the court has statutory authority over traffic offenses, will hear all the drunk driving cases. The only time you will get a drunk driving case in the superior court is if it's companion to some type of indictable offense, such as aggravated manslaughter or aggravated assault or something of that nature.
Well, but Bob, let me ask you this. Someone who's charged with aggravated manslaughter, I could plea bargain that. Mm-hmm. What about DWI?
Well, as long as you're up in superior court, you can plea bargain the DWI case, but the drunk driving cases that stay in the municipal court, they're not subject to plea bargaining.
So somebody who's charged with murder, you can plea bargain that, but someone who's charged with DWI, you can't, utilize the fact that this is an upstanding citizen who has a perfect driving record and he's going to lose his job. And
well, look about it in the context from the Supreme Court's perspective. You have a couple different things going on here, and I'm not suggesting one way or the other this is right, wrong, or different. I'm just trying to give the the reasoning the Supreme Court had in terms of having this prohibition against plea bargaining on drunk driving cases. When an individual's been charged with murder, he's going to be prosecuted by the county prosecutor, who is a constitutional officer with all types of checks and balances and things of that nature, subservient and supervised to the supervision of the Attorney General. Okay? Typically, the individual who committed the offense is going to be in jail, held on very, very high bail. So this is an individual who's really not a threat to the community at all. Contrast that with the municipal court, where the prosecutors serve on a part-time basis, although they're nominally subject to the supervision of the county prosecutor and the Attorney General. As a practical matter, they get no supervision at all. They're pretty much on their own. And most importantly, the person who's been arrested for drunk driving is out there still driving. He's running around all over the place. So the fear was, because of the part-time basis of municipal prosecutors, the number of other cases that they have to deal with, the lack of supervision that they have, that if they were to allow plea bargaining, they may be involved in situations where they'd be plea bargaining away otherwise meritorious cases. So for that reason, the court made a determination that the better way to handle it is to prohibit plea bargaining and also require that in most instances these cases be resolved within 60 days from the time of the date of the arrest. So there is kind of a big difference between the two classifications of cases.
I simply wanted everyone to know that you're not allowed to plea bargain these cases.
Yeah, just in terms of the general plea bargaining that you would go through with pretty much any other type of case in the municipal court context, there is some very, very limited plea bargaining, which we can talk about briefly, but by and large, you start with the proposition that there are no plea bargains on drunk driving cases, which means not only plea bargaining, but also sentence bargaining. You're not going to be able to lock the judge into a particular sentence as you would in other types of cases.
You're referring to school zone versus non-school zone, or
sure.
If the second offense, you could dismiss a refusal.
Exactly. Those types of cases. And of course, many times it's important to make recommendations as to sentence with the prosecutor, although again, it can't bind the judge because you can't plea bargain these types of cases. I mentioned a moment ago about the resolution of these cases within 60 days, and someone who's going to get involved with a drunk driving case really should know right from the beginning that there is a directive that requires that municipal court judges resolve these cases within a 60-day period. This has been something that's been with us for well over a quarter of a century at this point. And notwithstanding the fact that drunk driving cases have become enormously more complex than they were a quarter century ago, that's still the state of the law. So don't be surprised that you're going to get some pressure from the judge, or the prosecutors get a pressure from the judge to move the case within a 60-day time period. Now, in your vicinage, to what extent is that kind of honored in the breach, or is it really kind of a pressure you have to resolve the case quickly?
I think in my vicinage and in most places where I practice, judges understand that there are serious consequences, and if they see that an attorney is making a valiant effort to prepare a defense for their client, where they may need to utilize the services of an expert witness or expert witnesses, that the 60 days is unrealistic, and they will allow the attorney to go beyond that, because frankly, I think for them not to do that, they're committing reversible error.
Right. And it may be also that you need some discovery, which is difficult to get. Say, for example, you need the computer records related to the Alcotest instrument that tested your client, and you need not only your clients, but also going back a period of time, maybe 6 months. Mm-hmm. The case law entitles you to that discovery, plus the repair records of the instrument, but it may not be available to you, as a practical matter, for a substantially greater period of time than 60 days.
Well, a practice pointer for attorneys in handling DWI cases is to make sure they're familiar with Hollett motions.
Right.
In order
Can you talk
to
about what a Hollett motion is, Richard?
Well, yeah, that is a motion that a defense attorney would file to compel the prosecution to provide them with evidence that they need to prepare their defense, and upon failure to do so, there could be sanctions, including evidence being excluded, or in the extreme case, the case being dismissed.
The actual remedy that you have in Hollup is also echoed in the rules of court. So it's important that attorneys who are not getting the discovery they need file these motions. In fact, really, the appellate division puts an affirmative duty on defense counsel to not sit back, but actually go forward and try to get the evidence. And if you can't get it, there'll be sanctions for the state, typically with involving the exclusion of that particular piece of evidence. Sometimes that can be fatal to the state's case.
And you mentioned the constitutional guarantees previously that a defendant has in a DWI prosecution, and one of them is speedy trial.
Sure. Speaking of speedy trial, one of the things that holds the state up frequently from meeting their target 60-day disposition is in the drug and urine cases, because the state police, who are in charge of doing all the forensic testing of these blood and urine samples, sometimes there's drug samples involved as well, they're very, very busy, and the fact that the 60-day target disposition, really that applies to the judiciary, it doesn't apply to the executive branch of government. So it may be just because of the volume of work and budgetary constraints and personnel issues, especially if you have lab technicians that are out testifying all over the place instead of testing samples, that it could substantially delay the disposition of the case just because the prosecutor won't have the discovery back to give you, you know.
Not only that, but once you've made the demand that you want the state to produce certain witnesses, whether it's the state police chemist or a state alcotest coordinator, there aren't too many of them. And given the high volume of these cases, it can very often take quite a long time for the state to be able to secure them for trial.
Now, the whole trick to representing people in the criminal context, especially in the municipal court context, is to kind of gauge early on in your relationship with your client what your client's needs are. And you listen to what your client has to say in terms of what his needs are, and then talk to your client in terms of adjusting those needs to make them something that's realistic in terms of the outcome of the case. And I will just tell you as a practical matter, in a drunk driving case, even though you might have a particularly good case on the merits, it's highly unlikely that the defendant will escape without some level of license suspension. It may be something very, very short, unrelated to the drunk driving case, but just as a practical matter, if you look at from a probability standpoint, the likelihood of the client losing his or her driver's license for some period of time is extremely high. Would you agree?
Yes.
So that having been said, it's incumbent upon you as a defense counsel to kind of set your client's expectation.
Yes. There's other factors that I consider also in making a determination how to proceed with the case. For example, if I always have a form that I have my clients fill out, an intake form. And one of the things I want to find out, aside from whether they're a commercial driver or whether they're an illegal immigrant, an illegal alien, is do they have any prior New Jersey DWI convictions? Mm-hmm. And also if they are aware of what the state is going to claim their blood alcohol reading was. For example, was it a .08 or was it a .10? If you're
or .15
or a .15, if you're at, that's right, because we haven't talked about that yet either.
Right.
But those all are benchmarks that can really change the strategy of the case and the way that you would conduct your interview with the client.
Right.
And to explain to them, for example, I would generally tell a client who's received a DWI and a careless driving ticket and a .08 reading, let's go to trial. What do you have to lose?
There's no downside.
There's no downside.
Right.
You're not going to go to jail, even though technically you could be sentenced to up to 30 days in jail. The only time I'm aware of, in my experience, a client was sentenced to 30 days in jail and was led right out of the courtroom was when it was coupled with the second-degree eluding charge where I got an acquittal in 2 hours. Mm-hmm. The judge then, sitting as judge and jury, found my client guilty of DWI. It was his first offense. He sent him away for 30 days, and my client was thrilled. But aside from that, you're not going to go to jail.
I had a similar case with an individual who was operating a school bus while intoxicated with a whole bunch of little children on the bus. And I was thrilled to see him go to jail, and so was he, because it would foreclose the state from prosecuting him for child endangerment and other types of criminal offenses, you know.
Now, I recently had a case where a client was driving under the influence, was double the legal limit, and was going 50 miles an hour over the speed limit. Mm-hmm. That makes me worry a little. That might warrant some jail if it's not handled correctly. But putting those types of variables aside,
those are outliers. I mean, it's very unusual for someone on a first offense DWI in New Jersey to get some type of jail component. I mean, I've had it happen to me, but I've done thousands of drunk driving cases, and I can think of only two where it happened. One was the bus driver, and the other one, the judge was just having a bad day.
But my point is that there is certain information that you get that determines, you know, how you're going to advise your client as to what the conduct of the trial, what the conduct of the case would be, the progression of the case would be, and to set their expectations.
So let's talk about it step by step. Let's deal with a first offender with a BAC that's between 0.08 and but less than 0.10, or there is no BAC for some reason. You know it's going to be excluded. He's just under the influence of alcohol. I agree with you.
And not in a school zone.
Not in a school zone. I agree with you that there's no downside to trying the case. The best thing that's going to happen to your client is he's going to be acquitted. There's nothing worse is going to happen to him. He has absolutely nothing to lose by trying the case.
If they had a careless driving ticket, they'll get a fine, and they'll get 2 points, even though maybe the careless driving offense itself will be merged.
Possibly.
And then they just get the 2 points.
But he's not going to be any better or worse off by trying the case. He has absolutely nothing to lose.
No.
There would have to be something fairly significant companion to the DWI case, such as driving without liability insurance, or
leaving the scene of an accident.
Leaving the scene of an accident, maybe leaving the scene of an accident with personal injury. Mm-hmm. I mean, something where you'd really now want to leverage the drunk driving against these other offenses. So you have to look at the totality and say, look, the drunk driving at worst is going to cost you your license for 90 days. We can leverage that, plead guilty to the DWI, and in exchange for which you'll be able to get the driver without liability insurance charge dismissed, or the leaving the scene of an accident with personal injury dismissed. Something much, much more serious will have much graver consequences.
And those are violations that a prosecutor has the discretion to negotiate.
Correct. One of the exceptions on the plea bargaining rule for drunk driving, which is, and by the way, all these prohibitions and exceptions are set forth in the guidelines to the Part 7 court rules, or in the appendix of the court rules, Part 7. We're referring specifically to what's called Guideline 4. But the drunk driving actually has tremendous utility because you have other charges that are demonstrably more serious, assuming that your client A is a first offender and B, a 3-month suspension will meet his needs, okay? And you've got to explain that to your client ahead of time. Now, things get a little bit more complicated when the BAC is a 0.10 but less than a 0.15. Now you're dealing with a suspension term which at a minimum is going to be 7 months. It could be as long as a year. So, you know, the decision of whether you're going to want to go to trial or not becomes, the stakes are a little bit different in the sense that what's driving the case, what makes it a 7-month to 1 year suspension is the fact that the BAC is between 0.10 but less than 0.15, okay? So with that thrown in, if you can attack the BAC and eliminate it on whatever grounds, constitutionally or procedurally, whatever it may be, even though there may be a lot of evidence that your client was under the influence of alcohol, it's going to change the status of the case in the sense that now your client's looking at being exposed to a 3-month suspension as opposed to a 7-month suspension, right?
As long as it's their first offense.
As long as it's their first offense, non-school zone.
Yes.
Now, this kind of distinction in the statute came about in I guess it was 2004, when the legislature had to kind of finally adopt the .08 standard for New Jersey. And this is a political issue, and there was a lot of pressure from the various lobbying groups in Atlantic City.
Well, they wouldn't have gotten federal funding.
Atlantic City is the place where people go, by the way, to play poker and win $1,500, in case you had forgotten that. Liquor, hotel, entertainment industry, as a kind of a throw them a bone, so to speak. They created this two-tier system we have where if the BAC is between .08 but less than .10, the suspension term, and you're under the influence of alcohol, the suspension term is 90 days. Not greater than 90, not less than 90, it's just 90 days. By the same token, if you're under the influence of drugs, or alternatively your BAC is .10 or greater, then the suspension term ranges between 7 months and a year. Okay, so that's really kind of why that's in the statute, but it's significant because you have an individual who has that kind of level of BAC. You can actually do some pretty good work for your client, assuming that a 3-month suspension will satisfy your client's needs, right?
Yes.
And you may be able to defeat the whole case on the merits too. They may have a very weak case in terms of
observation
of the being under the influence.
You definitely will have earned your fee. Now,
I kind of hedge my bets by talking about this distinction about BAC that's under .15, because when you get to .15 and greater, it triggers some mandatory action by the court, and that deals with the requirement of the installation of an ignition interlock device. And this is an enormously important component to the sentence because while it requires, number one, that the defendant in most circumstances install the interlock device immediately upon the pronouncement of sentence, and then it will remain on the vehicle that's principally operated by the defendant or owned by the defendant for a period that's going to range, well, in a first offense situation between 6 months and a year, and for second and subsequent offenders between 1 and 3 years.
After their driving privileges have been restored.
After they've been restored. And just to make matters even worse, they are prohibited in New Jersey from operating any motor vehicle, any type of vehicle at all, unless it's equipped with an ignition interlock device.
And they can't have someone breathe into that device
to
start the
they
car.
Can, but I mean, it's an offense. You can be prosecuted. I think
that's right.
It's just a really person's offense. So the bottom line is that the ignition interlock device is a significant, I don't know that it's necessarily a penal consequence. It's certainly a collateral consequence, but it has an enormous monetary impact on the defendant and his family, and can really restrict your ability to work, because unless you're going to be assigned a work vehicle that has an ignition interlock device on it, it's going to be really tough to find employment, you know. So once the BAC is .15 or greater, that's when this becomes mandatory. In those situations where you're dealing with a first offender, it's only first offenders, and the BAC is under .15, the judge then has the discretion to either order or not order the installation of the ignition interlock device. And again, this could be an extremely important component of sentencing, again, helping to meet your client's needs, that he's not going to have to deal with the expense and inconvenience of an ignition interlock device, not only on his private vehicles, but also on vehicles that he's going to operate after he gets his driving privileges restored. Do you agree with all this?
Yes, I do.
So how do you handle this with your clients?
In some regards, in my own experience, I found it difficult to reduce a .15 reading because there's some question whether that's still plea bargaining. I mean, if you eliminate the reading altogether, then you're talking about a 3-month loss of driving privilege for a first offender. I did have a case recently where, the judge agreed that, and it was really something that the prosecutor initiated. It's the only time that ever happened to me, and perhaps I shouldn't go into it in great detail, but it involved a stipulation that my client's reading was a .10 or above.
Right.
But the actual reading wasn't introduced into evidence at the time of the plea.
Okay. So your client was he was subject to a 7-month suspension, but did the judge deem it to be less than .15 and then not impose the interlock
That's right.
device?
The judge deemed it not to be a .15.
Sometimes you have to think out of the box in these cases, and I guess if the prosecutor and you and the judge agree and it calls for otherwise what is a legal sentence, who's to say? But
Yeah.
the reality I'm trying to point out to our viewers is this, Rich, that if 100 cases walk into your office and they're all charged with drunk driving, you've got to start with the proposition that the vast, vast, vast majority of them are going to have their cases resolved by way of some type of plea and sentence agreement. Okay? And within the parameters of the guidelines, it will be unusual for you to try these cases because many times there's nothing to try. There is no factual issue, or there's just too much incentive to plead guilty because of other cases and charges that are going to be resolved favorably, again, meeting your client's needs.
Right.
You, as the attorney, have to figure out all these issues, and it may be interlock device, it may be the length of the suspension, it may be dismissal of other charges, it could be other collateral consequences. There's a whole lot that goes into the mix. So you start with the proposition that the likelihood is the case is going to be resolved by way of a plea. Now, how can I structure this plea so that the judge will find it to be in the interest of justice, that the prosecutor will be happy with it, the victims and witnesses will be happy? In other words, that the needs of everybody will kind of coalesce at the time of the plea colloquy.
Well, that in the absence of this case might warrant a reduction of a blood alcohol reading to below a 0.10 or to below a 0.08. I'm wondering whether or not that argument could still be used, not on a guilt or innocence issue, but perhaps on a sentencing issue with the 0.15.
Well, the rules of court certainly, the guidelines prohibit that explicitly with respect to a 1.0 going to something under than 1.0. But the Supreme Court has not, as of yet, and probably after watching this they will, promulgated anything that prohibits that type of consideration on a 0.15 because of considerations with respect to the alcohol test. I think that might be below the radar screen at this point, but if the court becomes aware of it, they'll have no problem with amending the guidelines.
Well, until then, it's not in the guidelines, and it might be a valid argument to make for your client if the precision argument would apply.
Well, we'll have to see. I can tell you what the Supreme Court's going to do when they find out about it, though. I want to kind of go through quickly what the sentencing parameters are, just in very basic terms, so that when new attorneys who are reviewing this have clients that come in, they can talk to them a little bit about what the sentences are going to be. Mm-hmm. First of all, I want to talk about the first offenders. Again, we're not talking about school zone cases here. For a first offense with a BAC that ranges between 0.08 but less than 0.10 or no BAC at all, you'd be looking at the following: a fine that ranges between $250 and $400, together with an additional $364 of state-mandated court costs and assessments that get added on to whatever the fine is going to be. A 90-day suspension of driving privileges, a requirement of participation in the alcohol, the IDRC, which is a kind of an alcohol education program, for a minimum of 12 hours, which can be extended by the judge to as long as 48 hours.
That's the Intoxicated Driver Resource Center.
Correct. And then finally, the possibility, although it's extremely remote, of a jail term of as much as 30 days, and the option that the judge has of requiring the ignition interlock to be installed. With a blood alcohol reading above 0.10, you'd be looking at the following: a fine that ranges between...
A 0.10 or above.
0.10, right. Blood alcohol reading of 0.10 would result in a fine that ranges between $300 and $500. Again, $364 of state-mandated court costs and assessments. A suspension of driving privileges, which will range between 7 months and 1 year. Again, the Intoxicated Driver Resource Center, between 12 to 48 hours. Possibility of a jail term of up to 30 days. And in those instances where the BAC is at least a 0.10 but less than 0.15, the judge will have the option of ordering the ignition interlock device. In those instances where the BAC is 0.15 or greater, it's mandatory. The judge has to order it in every case. For first offenders, the range of the interlock device is between 6 months and 1 year. Interesting, there's a little bit of an anomaly in the statute, and it really has no significance at all. But in those instances where the BAC is under 0.15 and the judge decides he's going to require that the defendant install the interlock device, the defendant's obligation to install the interlock device does not begin until the suspension term is over. Every other time, you have to have it installed upon the pronouncement of sentence. That's just one crazy exception. I think it's more of a mistake by the legislature than anything that was done intentionally. Now, You're entitled to be treated as a first offender under New Jersey law, even if you've had a prior offense in New Jersey or another state, but there's been more than 10 years since your prior offense. So it goes from offense date to offense date, and if the previous offense date was 10 years or longer, then the judge must sentence you as a first offender, notwithstanding the fact that factually it's your second offense. If you're convicted of drunk driving and you have had a second offense within the prior 10 years, you're subject to the following penalties. And again, these are all set forth in the statute. A lot less discretion for the judge on the second offender. The fine ranges between $500 and $1,000. Again, $364 of court costs and assessments added to that. 30 days of community service. A day of community service is 6 hours long, so we're talking about 180 hours of community service. 2-year suspension of driving privileges. Not less than 2 years, not more than 2 years, 2 years.
Every client is going to ask you, there is at present no work permit. It is a total loss of driving.
The only thing you can drive is your hush puppies. There is a minimum mandatory 2-day jail term, which can be extended by the judge up to 90 days. Most people don't do any jail terms on second offenses because the statute allows you to satisfy the 2-day jail sentence in the Intoxicated Driver Resource Center. Typically, for a second offender, there's a 48-hour Intoxicated Driver Resource Center obligation. You actually literally have to stay overnight the second time through, so that's why the judge can give you credit for time served on your sentence. There's a statute that permits that.
And with any IDRC, the counselor can require up to 1 year of a form of outpatient treatment.
Correct. The final aspect of it, of course, is the ignition interlock device. That is mandatory. It's for second offenders. Minimum period of 1 year, could be extended by the judge up to 3 years. And the way it works typically, let's say the judge gave you a 3-year obligation, you'd actually be stuck with the interlock for 5 years because technically you'd have to have it installed immediately, so it would be on your vehicle for the 2 years that you're on the revoke list, then for another 3 years after you've gotten your license restored. So, I mean, that's the worst case scenario, but you should understand that you do have this obligation after your license is restored for 1 to 3 years with the ignition interlock device installed in your vehicle.
Before you talk about the penalties for a third offense, practically speaking, what do you say to a client who's faced with that and then says, well, I'm just going to sell my car?
Well, I would tell them to go sell your car, but I would also tell them that you're still not going to be able to get your driving privileges restored in New Jersey until you show proof to the Motor Vehicle Commission that the vehicle that you principally operate has an ignition interlock device on it. It's a weird statute because it was done in 2 parts. One part of it just limits it to the vehicle that you principally operate, but the next section of the statute requires it on vehicles that you also own. So the only thing I can tell clients with some level of assurance is that the Motor Vehicle Commission will not restore your driving privileges until you demonstrate to them that you've installed an ignition interlock device on some vehicle. Typically, it's going to be the vehicle that you principally operate. Otherwise, they won't restore your driving privileges. Yeah. Now, for third offenders, again, we're talking about non-school zone. It's very, very simple. I don't think that there's really any discretion in the court at all, with the exception of how long the ignition interlock device is going to be. The fine is $1,000. There's $364 of court costs that get added on to the fine. 10-year suspension of driving privileges and 6 months in jail. And you've got to prepare your clients for this because if they plead guilty and it's a third offense, they're going to be led out of the room in handcuffs that day, unless there's some type of really extremely compelling reason for them not to start their jail sentence. The municipal court judges are under orders to make sure that the sentence starts right on the spot and the defendant goes from the courtroom over to the county jail. The interlock device is the only place really the judge has any discretion to speak of, and that's going to be for a period of between 1 and 3 years on the third offender.
After they get their driving privileges.
After the 10 years has gone by. So theoretically, if the judge really wanted to clobber you, you could have a 13-year commitment. I mean, 10 years you'd have to pay for it while you're not allowed to drive, and then another 3 years thereafter. This is nasty stuff, isn't it?
Yeah, it sure is. It's enough to drive you to drink, but just don't do that and drive.
Now, once again, you are entitled to the so-called step down if you've had 10 years since your second offense. So your second offense, again, going date of offense to date of offense occurred 10 years earlier. You're in a position where you would be required to be sentenced as a second offender for sentencing purposes, right?
Yes, but let me ask you a question about that. Suppose I had a DWI and then 10 years later got another DWI. And then 10 years after that, I got another DWI. Is that my third, or am I entitled to a second step down?
Well, do you want to know what the law is, or you want to know what I would do by way of advocacy?
Well, I know what we would do by advocacy. Let's find out what the law is. There isn't really any law on that issue, is there?
Well, I thought there was. There was an appellate division case called State versus Burroughs, which I thought kind of settled the question, but I'm not so sure anymore. Our Supreme Court had this issue before them in a case called State versus Cingolini, and they specifically reserved on this issue and discussed it and said, they gave it the old, we need not decide because the issue is not directly in front of us. So it's hard to say how they would rule on this particular issue. So I'm hopeful that at some point some attorney will have a case that will get that far and get them interested in answering the question that they left open in the Cingolini case. For present purposes, I don't know the right answer, and I don't think anybody does because the court has reserved on answering that issue.
Yeah.
So now I wanted to talk kind of quickly about the school zone offenses, and I have to tell you that school zone offenses, although they kind of started off with great promise, have not really panned out in terms of an enforcement tool. The rules of court, the guidelines permit a dismissal of the refusal charge in exchange for a plea of guilty to the underlying drunk driving case in those instances where there was no accident and no children were present in the school zone. In other words, the school property wasn't being utilized at the time that the drunk driving offense took place.
Well, it may not be effective as an enforcement tool, but it certainly becomes effective as a prosecutorial tool.
Very much so. And this is one of the things that prosecutors can do to kind of beat pleas out of people. And talking about meeting your client's needs, when you're talking about a school zone conviction, which would essentially double all the major penalties that you would face with the exception of the jail sentences for third offenders, because as we said before, you can't get more than a 6-month jail term. But it becomes a tremendous incentive when there's a school zone in play for the defendant to plead guilty. So you have to look at the statute to see what the penalties are, but basically they're doubled. The fines are doubled, the license suspensions are doubled. The only thing that's really not doubled is the third offender jail term, which could not exceed 6 months.
And considering the fact that I would say the vast majority of driving while intoxicated offenses occur in the very late evening or very early morning when most schools are closed, doesn't matter.
Assuming that you haven't had an accident, it really wouldn't. I agree with you. It wouldn't matter.
No, I mean it wouldn't matter in the sense of the state being able to prove the offense. If you're within 1,000 feet of a closed school, it's still a school zone violation.
Oh, there's no doubt about it. I mean, the school zone is intended to establish a 24-hour-a-day, 7-day-a-week safety zone for people who are in the vicinity of the school. You can really commit the school zone offense in 3 different ways. Number one, operate a motor vehicle while under the influence of alcohol through the school zone. That's number one. Number two, operate through a school crossing, which has been designated as a school crossing by ordinance or resolution. And number three, operate through a school crossing that hasn't been so designated when there are children present. Those are the 3 main ways that you violate the statute. It's important that you understand the option of plea bargaining these cases away. And what's unfair about the statute, of course, is that it's really just a question of territory. If you're talking about inner city areas, virtually every inch of the municipality will be in a school zone, just because of the way people are packed together. In the more rural areas of our state, schools are few and far between.
What about an officer following a car for a mile or two until they get into the school zone?
I'm not even sure that they have to stop them in the school zone. If they just pass through the school zone, they can make a school zone case.
But maybe what I'm saying is they haven't even arrived in the school zone yet when they're first observed.
The police wait until you're in the school zone and make the stop there. I'm sure that type of thing happens all the time. But just in terms of the actual prosecution of the school zone cases, it's really kind of fallen into disfavor because it's such a powerful tool for prosecutors to utilize to get pleas out of individuals. So in that sense, it's an important component of drunk driving prosecutions. And if it meets the needs of your client to avoid the school zone, that's fine too. But I just want everybody to know that that's kind of out there. Mm-hmm. Now, the last thing I want to talk about today, Rich, is just really some nuts and bolts things that you can do as a defense attorney to get these cases ready. We've touched on all these things, but I want to kind of organize them step by step. First is clients in your office. We've talked about ascertaining what your client's needs are going to be, right?
Yes.
You make a determination as to what you think those needs, what needs can be met in a statistical sense. In other words, that the highest probability in your mind, given this type of case, given the evidence, given who the judge is, who the prosecutor is, who the police officer is, all the extraneous factors that you utilize your experience to take into consideration, you say, I think the case can be resolved in this particular way, and adjust your client's needs accordingly, right?
Yeah, I wouldn't say I think that it could be done this way.
Oh, no, I'm
I
not
would say
suggesting...
this would be our goal.
Right. I mean, but in your own mind, you're making statistical probability determinations.
There are so many variables, many of which you mentioned, that an experienced practitioner considers, and someone who is gaining the experience develops their own mental library about.
And what's critical, though, is when you're making this assessment, you can't rely on what your client tells you because they're mistaken, they don't tell the truth, they forget things.
Well, they're often intoxicated, and that affected their perception and their memory and their judgment.
Exactly. So you're really not going to be able to make a final determination with any level of assurance until you've seen the police reports at a minimum. But yet, initially, you've got to tell your client something, so you'll make a determination roughly with incomplete evidence. Mm-hmm. So it's an imperfect estimate, but you've got to do it. Mm-hmm. And then later on, if it turns out that something was inaccurate, then you can come back and discuss it with your client further. But your client should be leaving your office with some level of expectation about how the case is going to go.
Yes.
Now, after that, you're going to make a demand for discovery upon the prosecutor. This is done in writing and should be done simultaneously with the entry of your appearance with the municipal court. This is the rules of court require this. It's the prosecutor's responsibility to provide you with the discovery. And once you get it, you'll look through it. If you're missing something, you'll either make an additional demand for discovery or file some type of motion, maybe a haul-up motion, as we talked about before. You'll have your client come in and review the discovery with you.
Yes.
Review the videotape as well.
Yes, and you know, be aware that some of the information, such as a video or a dispatch tape, may not be preserved unless you make a timely request for it.
Right.
So make certain that you do that.
Now, typically, if you're a young attorney not particularly experienced with these things, you have certain ideas about how you'd like the case to be resolved. My sense is that it serves no useful purpose and actually can backfire on you to contact the prosecutor outside of the context of the court. It's much better when you're at the court with the prosecutor there, with the judge, with the police, with everybody else, access to records or whatever it is. Talk to the prosecutor at the court, not in his private office. It's just really kind of psychologically much better to do it that way. Prosecutor, when he's at his office, he's doing his own private law stuff and is likely not to have all the papers that he needs to make a determination.
I have found that to be the case very often. In fact, I would go so far as to say that I wait until everything is coalesced in the courtroom and just before the courtroom in the prosecutor's prosecutorial office, rather than discuss things earlier in his private office, because sometimes that just makes them dig their heels in more.
You've got to be very careful about how you handle yourself, just to be professional about these things, and especially if you're out of county. And this is really the subject of another CLE that we could do, which it's just such a nuanced thing, but it makes all the difference in the world in terms of how you handle yourself, especially when you're dealing with people who don't know you.
Right. Right. One bit of advice in general. Try cases.
That's
if
right.
The prosecutor knows that you try cases, that you know how to try cases, they may evaluate the case that you have for your client a little differently.
Remember, though, that you may have a tremendous desire to try the case, and I think that that's wonderful. You don't get experience on trying cases by doing anything other than trying cases. The next best thing you can do is watch people who are really good at trying cases and sit in municipal court and watch them do their thing. But trials are so rare in municipal court these days, you're going to have to look really hard to find that.
And also, you don't have a trial against your client's wishes.
And that's
obviously.
the key thing. I mean, we can't lose sight of the fact that it's not your case, it's your client's case. You've made a determination jointly with your client as to what is going to meet his needs. And if you can put something together that approximates that or is satisfactory to your client or meets his needs or exceeds his needs, that's going to be the termination of the case. That's what the case is about, not necessarily building up an experience level that you can utilize for future clients. Right. So if you have nothing to lose and they're not offering anything, you try the case and you'll get a lot of good experience. And you know something? A good case only gets worse, but a bad case sometimes gets a whole lot better.
Yeah, especially in Alcotest cases.
Exactly. So any final words of advice to the young attorney who's just kind of starting off and getting his first drunk driving client in?
You'll enjoy it. It's profitable. It's challenging. It gives you an opportunity to meet a lot of different judges, a lot of different prosecutors. The cases are interesting. And we've really just, believe it or not, I don't know how long we've been talking, but we've really just scratched the surface.
And I was just thinking the same thing. We have so many, hundreds upon hundreds of cases that you really have to be familiar with, and of course the complexities of the statute. And
post-conviction relief.
Oh, sure. You have post-conviction relief, you have motions to suppress evidence, you have technical and scientific defenses that you can raise. We really have not scratched the surface. So there is a significant learning curve associated with all these things. But by the same token, you can't learn it all overnight. The only way to really kind of get to know it is to take your first client, take the case forward, and see what happens.
That's right.
Rich, thank you very much for helping us out today.
Well, thank you for having me.